16-10 State versus Jonathan, is that Ybarra? Charged with sexual indecency with a child, indecent exposure, disorderly conduct. Are we here on arraignment? Is that correct?
Yes, Your Honor. I've stood with Mr. Ibarra at his 8.1. I don't know if he's applied yet. We haven't received it if he has.
Sir,
I'm
have you
sorry.
made an application to the Public Defender's Office?
Yes, sir.
You have
Anthony.
made one? Okay, we'll run that down. For the time being, I'll have the Public Defender represent him. How does he plead?
He'll plead not guilty, Your Honor.
Okay. Your case is before Judge Webb. You appear on February 4th at 9 o'clock a.m. Anything further?
No, Your Honor.
Thank you, sir. That's all I can do right now. State versus Christian Blake Sisk, 1609. Wherein he's charged with breaking or entering in theft. Like he's here on arraignment, I think. Do you intend to hire a lawyer or make application to public defender?
Public defender. I've already got John Russo on my other charges.
Judge,
Okay.
he has some charges that aren't listed here. 16-2 is also a pending case.
All right.
We'll waive reading of the information or plead not guilty for him today on these.
Okay. And did these need to be transferred so Mr. Russo can
Yeah,
represent you?
that would be great, Your Honor. I believe only one of them falls on your docket anyway.
Okay,
The other two would be.
We'll transfer your cases to Judge Webb's docket. So it sounds like you and Mr. Russo already having a relationship, so we'll leave that. Anything else we need to do?
Not from us, Your Honor.
Well, thank you, sir. State versus Terry Teeter, 15-405, 15-394, 15-321. Looking at 15-394. Leaving the scene of an accident involving personal injury, controlled substances, traffic violations.
Judge, it's my understanding that all three of these cases have now been officially transferred to your docket. Is that correct?
Okay. I'm looking at, at 15-394, we have a pretrial set on February 11th. Is there anything else we need to do today? If he's
Sure.
not entered a plea of not guilty, we'll of course do that.
Right. We would obviously do that this time. We'd also like to be heard on bond today, Your Honor.
Okay, well, let me look at the cases and then I'm looking at 405, which is unlawful use of a communication device, delivery of methamphetamine. Looks like we need to enter, he appeared before Judge Webb apparently. Is that correct? And entered a plea of not guilty in that case? Does that sound right?
Judge, I wouldn't have been. Yes, that's correct. I see just
Okay.
an order here.
15-321 is a theft case and a variety of charges here. Okay, there was a plea that's back in, this case is working along, isn't it? There was a motion to revoke bond. That's why one reason he's incarcerated. Look at the scheduling order. Trial set on February 1st as we speak. What did you want to say in regard to bond?
Your Honor, it's my understanding, and I could be wrong. It's my understanding that bond was reinstated, but put at $250,000 for all three cases. I don't know if the documents before the court right now reflect that. That was my understanding of the status.
That's exactly right. We had a bond. We made the same motion was made on December the 22nd before you, and it was your decision at that time that his bond would be $250,000 if he with an ankle monitor. We actually raised this man's bond primarily because of what the court just listed. Mr. Teeter has been involved in criminal activity since September, and that culminated in the death of a young man, 20-year-old young man, a 22-year-old young man. And at that time, on December 22nd, this court raised Mr. Teeter's bond to $250,000 with an ankle monitor. It is of note that in the last case, while that after that accident occurred, that this gentleman ran from the scene. And, Your Honor, it was for that reason that I argued in December. I don't think anything's changed other than Mr. Teeter's been in jail for 30 days. I argued that at that point, Baxter County needed to be at least held safely from Mr. Teeter. Judge,
Well,
you don't need to reduce his bond at all.
Judge, if I may, I believe that part of the reason that the bond was put where it was because there was talk that the state was going to amend these charges to something much more serious than what it has been amended to at this point in time. That has not happened yet, as far as I know. It could be happening today, but I have not seen those documents at this time. That being said, I think that Mr. Teeter, his appearance before this court can be secured by a much lower bond, and we'd ask the court to consider that.
Your Honor, I'm not concerned with this gentleman being here. He is of no danger to anyone in this room or this community as he sits here or he sits in court. And yes, we are waiting on the crime lab for results to see if we're going to charge this gentleman with another crime. And those crime lab results are not here yet. We don't have them. We haven't made that decision. But what's more important here is that September, October, November, December, in those 4 months, this gentleman did things that hurt people. He hurt himself, but he hurt other people. And that is in keeping with what the court did on February the 22nd, which was to take this man's bond and raise it. And now we're 30 days later, and I do not understand that, Judge, now I want you to lower it.
where does he reside at?
Judge, he lives here in Baxter County. His father, I've been in contact with, and I believe he will live with his family if he's out on bond.
Does he? Go ahead.
I'm sorry, he is married. His wife is a nurse here in Mountain Home. He has a child. They live in Gassville, I believe. Is that right, Terry?
Yes, sir.
Yeah, they live in Gassville. Again, Your Honor, we not making light of the allegations against Mr. Teeter, but at this point in time, I believe it's a claim of negligence, criminal negligence on the state's part. Unfortunate death of this individual is incredibly sad. We're not discounting that. My client has felt the effects of that car wreck every day since it happened, both physically and mentally. However, we would ask the court to consider that bond is not to be used for punishment, not to sentence someone before the facts of the cases can be heard, and that his reappearance before this court can be secured, and ankle monitors, drug testing, whatever the requirements of the court placed upon him, we would ask for that to happen.
Say I set the bond at $250,000 plus an ankle monitor. If you will do this, if you will check into a GPS ankle monitor, which tick by tick, we know where he's at. And I might put him on house arrest and reduce the bond somewhat. But the thing about it is, we want him to appear. We do not, assuming he may have, be out harming someone. But if you'll present me with something where we can have controls over this situation, I will consider that.
Thank you, Your Honor.